All right, everyone. All right, I think we're ready for our second talk now. This is Ben from USAA, and he'll be talking about web accessibility.
All right, where's
All right, so give it up for Ben.
I probably need to turn this on, don't I?
Yes, you do.
Where's the? I promise I can computers. Oh, it's the big switch that says on off.
Yeah.
For future reference.
Got it?
Oh, there we go.
Right.
Awesome. I'm loud. This is nothing new. I'm a very loud individual. Hi there, guys. My name is Ben Myers, and I am a software developer at USAA here in Plano. We're actually not that far, just like 10 minutes, I think, was my drive. I've been with USAA a grand total of 1.5 years after I graduated college. And before that, I did an internship at USAA. I wear quite a few hats. So I'm a full stack developer. I'm doing stuff for React and Redux, but I'm also working on Java backends. Additionally, I'm involved in mentoring USAA's college hires, introducing them to the world of React development. But that's not what most people around USAA would know about me or know me for. You can ask Joe. I pride myself on being a champion for web accessibility. So if you guys aren't familiar with the world of web accessibility, what that means is just basically programming your pages in ways that make them friendly to users with a wide variety of disabilities who might be interacting with your page, for instance, with a wide variety of assistive technologies. This is something that I'm hugely passionate about, and I'm very excited to be able to share just one corner of that world with you guys tonight. There's a big, nasty word up there, compliance. I know case law as well. Y'all probably didn't go to a hot tech startup meetup to talk about the law. Last I checked, this is not a lawyer meetup. However, I promise you, this stuff is really engaging. It's a really lively debate that's going on right now as we speak. And web accessibility is so huge for so many people. According to the U.S. Census Bureau, about 1 in 5 Americans has some significant disability. That's huge. That's 1 in 5. And those people are trying to use your services. We have to be accessible for them because it's the right thing to do, but also probably because it's the law. But the first thing that I want to emphasize, right, is it is the right thing to do. It is a necessary part of just being the best that we can. And I assure you, if you're attending a meetup for development, you're already interested in being the best you can be. All right. So, yeah, compliance. Not a very friendly sounding word. But I want to assure you of something. Compliance is about, first and foremost, protecting real people. So, confession, I work in a bank, right? We're no stranger to compliance stuff, right? But every bit of compliance that comes our way is because there are real people whose lives are at stake, whose ability to manage themselves independently are at stake. One example of just how web accessibility fits into that picture that was made really clear for me was that many elders, for instance, can be taken advantage of financially by like younger people, right? They're older, maybe they're less able to take care of their finances, and so some younger relative takes over the finances and, pockets, a few $1,000s here and there. And the same can be said for many disabled people. If we don't enable our disabled users to manage their finances or whatever it is you're doing with your applications, we are instead setting them up to be taken advantage of, and that can be a security risk. So compliance is first and foremost about protecting real people. I should mention, by the way, that URL down there in the bottom, that's if you want to access the slides, also my contact information. Okay, so if you're talking about something as compliance, there are always two questions you should ask yourself. First of all, does the law require it? Which law? How? And second of all, what standards are you being held to? And so those are the questions that those in the web accessibility community are dealing with, but not just the people in the web accessibility community, but disabled users themselves. It is a truth that there are many web accessibility lawsuits going on as we speak. Last year, there were about 6 web accessibility lawsuits spun up every day. That's a lot. And if you don't have any clear answers to these questions, that can be a huge problem. So we're going to, today, try to figure out the answers to these questions. Now I have to address the elephant in the room. Some of you guys probably follow the news, and you're aware of some pizza-related web accessibility news. Trust me, we'll get there. I promise you, we'll get there. Come with me on this journey first. All right, so first of all, there are no federal laws that directly mention or deal with website accessibility specifically. None. And that's really odd. How can we be in a position where we're talking about litigation if there's no laws we can point to? Well, the closest thing that we have is the Americans with Disabilities Act, specifically Title III, which prohibits discrimination on the basis of disability in the full and equal enjoyment of the goods, services, facilities, privileges, advantages, or accommodations of any place of public accommodation. There'll be a quiz, I get? No quizzes. But this is the closest thing that we've got. So what this means for us is that the question of whether websites have to be accessible by the law is actually strictly equal to the question, are websites public accommodations? If we can show that websites are public accommodations, then they're covered by Title III of the Americans with Disabilities Act, and so therefore we have to make them accessible. It's here that a definition of public accommodation would be really, really nice, wouldn't it? Now, I'm no lawyer. I'm not. Please don't take legal advice from me. But I would like a definition of public accommodation, and I find it really weird that there isn't one. There's not. The Americans with Disabilities Act instead defines a list of examples of public accommodations. There will be a quiz on this one. There's a lot of stuff on this. There's restaurants, there's auditoriums, there's laundromats, banks, insurance offices, travel services, and a whole lot of or other X. This list is very vague, but nowhere on here does it mention websites. So we're still kind of at a loss. We've got no clear sense of, are websites public accommodations? Who says? And so through all these web accessibility lawsuits that we're seeing, courts have actually split up into 3 different opinions. And they've ruled on cases with these opinions, which means that we have lawsuits with conflicting results out there. So kind of keep that in mind, right? There's different opinions going on, and not all of the case law will agree with each other, which has a lot of compliance people and a lot of auditors very, very frustrated. All right, so the first opinion that I want to talk to you guys about is the opinion that websites are public accommodations. They are inherently public accommodations. The precedent actually comes from the 1990s. There was a store called Car Parts that was suing an insurance office. The insurance office operated over the phone, but the case effectively found that you can still sue companies for being inaccessible and discriminating on the basis of disability, even over phone lines, not necessarily physical public accommodations. Their justification for this, by the way, is wild. If we go back to this list right here, somewhere, let me see, right here, it says travel service. And this is the 90s we're talking about. Now, I was born in 96. I'm a youngin'. But one of the things that I found in my history textbooks is that apparently even then, travel services were not physical. largely. They were telephone-based. Apparently, people back in those days used to use a telephone. So this is back in the 90s when this case is happening, and they look and go, huh, Congress wrote this law, and they included travel service, which is largely non-physical. So therefore, Congress clearly intended that the Americans with Disabilities Act covers non-physical public accommodations as well. And since then, that case has been used a couple times against Netflix or Stripe D or Blue Apron to say, like, hey, because non-physical public accommodations are still public accommodations and therefore covered by the ADA, you guys have to be accessible. Now, if all of this has you feeling a little like this, you're not alone. That opinion, the opinion that websites are inherently or intrinsically public accommodations, it's actually pretty fringe amongst most courts. The second most popular or second least popular of the three opinions is that websites are not public accommodations. And their justification here goes, well, if you look at the letter of the law, it doesn't say public accommodation, it says place of public accommodation. And websites aren't places, checkmate. You don't actually see a whole lot of web accessibility lawsuits in the circuit courts that believe this, because that would be a little foolish for the plaintiff. No plaintiff is going to sue if they don't believe that the circuits are going to back them up there. So there's not a whole lot of like direct web accessibility related precedent in these circuits. But the third, and by far the most common opinion that these courts have about whether websites have to be accessible or whether they're public accommodations is to sidestep the matter altogether, typical lawyers, and instead declare that websites can be extensions of public accommodations. And this is because if you, here, let me scroll back here. It says, no individual shall be discriminated in the full and equal enjoyment of the goods, services, etc. of any public accommodation. It doesn't say in any public accommodation, it says of any public accommodation. So therefore, if we can prove that, you know, your website is like acting as a proxy to something that we already know is a public accommodation, like say the website for a pizza chain, then the website's effectively an extension of the public accommodation, and therefore it must also be accessible. The principle of connecting a website to some physical public accommodation is called Nexus. And this Nexus argument has been used both ways, to both protect and fine websites. In the case of, let me go back here. In the case of Winn-Dixie, for instance, the Winn-Dixie grocery chain, the Winn-Dixie website offered the ability to refill prescriptions online, but you had to pick them up in store, as well as they offered coupons online that you had to redeem in store. So the courts looked at this and thought, huh, that Winn-Dixie site, that's definitely like acting as an extension to the, yeah, it's definitely an extension. Okay. So Winn-Dixie was fine because their website was an extension of their public accommodation brick and mortar stores. But meanwhile, we've got sites like eBay or Southwest Airlines that have no like brick and mortar consumer open location that you can visit. So because eBay and Southwest Airlines are not public accommodations, their websites don't have to be accessible either by this opinion. There's Dominos there. Domino's has a bit of a storied history, and this is where we return to the elephant in the room, the one with pizza. Elephants are ugly. I'm just gonna say it. All right. So there's been a particularly high-profile web. What's it?
Who else is playing Alabama ball? Smash up an elephant.
I mean, I'm not from Alabama, so I can dunk on the elephant as much as I want. All right. so the Dominos case has been especially high profile, and it's a really storied case. So I want to kind of walk you through the timeline, because this is a case that you guys have likely heard about in the news very, very recently. The most recent development came from the Supreme Court a month ago. So this is still fresh on our minds, but in my experience, there's been a lot of misinformation about this case, or a lot of lack of information. So I kind of want to, I guess, set the record straight and let you guys know kind of what's hot in the wonderful world of web accessibility. All right. Guillermo Rogels is a blind man. He attempts to order a pizza twice off the Domino's website, but he can't because he's using a screen reader, and it turns out the Domino's website not super friendly to screen readers. So in September 2016, he decided, hey, it's time to sue Domino's. Let the pizza chain burn. Then March of the next year, the district court saw that case and thought, well, we agree that websites have to be accessible. We're not sure the standards are quite fleshed out enough for us to litigate on this case, so we're just going to throw it out. Guillermo appeals. And then in January of this year, the Ninth Circuit Court, which is, for those who aren't familiar with the court system, it's like one level below, the circuit courts are like one level below the Supreme Court. Guillermo appeals the case, and in January 2019, the Ninth Circuit says, actually no, we believe that the law is concrete enough there, you need to hear the case. Domino's, not super happy with this. You know who's also not super happy with this? A whole lot of other businesses who start to realize that, hey, we're kind of getting hammered by lawsuits. So a whole bunch of businesses start, including like the whole U.S. Chamber of Commerce, started filing amicus curiae briefs in favor of Domino's, and Domino's appeals to the Supreme Court. They're like, we're going to end this thing once and for all. No more questions. Do websites have to be accessible? Do they not? We think the Supreme Court should decide. And last month, the Supreme Court made a stunning announcement. They will not decide. Instead, they refuse to hear the appeal, which means that the Ninth Circuit's decision for the case to be heard still has to go through. The case has not been heard at all. This case has not been seen, not come before a jury at all. But this case still has to go through. Just like all of the other web accessibility cases that are going through. But if you read between the lines, here's what I think about this case. Here's what I think you should take away from this specific case. The Supreme Court maintained the status quo here, right? There are, as I mentioned, 6 accessibility lawsuits filed every day. And the Supreme Court had the prime right opportunity to weigh in, to say whether websites should be accessible or whether they should not be accessible. And instead of saying, no, they don't need to be accessible, that would be nice to have, but they don't need to be, the Supreme Court instead opted to keep this litigation situation as is. And I think if you look at that, like that leans in favor of the disabled plaintiffs who are just trying to use the web. That's how I interpret this case. Again, not a lawyer, but that is my understanding of this. So we've gone this very long, roundabout path to answer only the first question that I asked you guys, which was, do websites have to be accessible? Fortunately, the second question is much easier. Which standards do we have to abide by? And the answer to this is pretty clear. The Web Content Accessibility Guidelines 2.0 AA tier seems pretty straightforward. So these are standards that are published by the World Wide Web Consortium, which publishes, all of the other HTML standards that you might be familiar with. And while these standards are not specifically enshrined in any American law for public companies, there are numerous reasons to believe that this is the way to go. If you're interested in making sure that your website is accessibility compliant, you should follow these standards. And the evidence for this is, Section 508, which is the similar law, but for specifically the federal government, does actually condone these standards. It's an industry standard, and many cases, including Winn-Dixie and the Dominos case, in their reparations, the courts have specifically recommended, like, if you want to do right by your customers, you have to go to these standards. And also, in all the research that I've done on web accessibility case law, which is there, oh god, there's so many pages to read. In all the research that I've done, I've never actually heard of a website that got sued that was WCAG 2.0 AA compliant. So you guys should really take some time to read through these standards. Just a brief introduction to them, by the way. There are 3 tiers. There's A, there's AA, and then creatively AAA. A is like the bare minimum, like, oh yeah, you probably have some alt text. AA is, we are reasonably confident that this will work with just about any assistive technology, reasonably work well with just about any disability. And then there's AAA, which is like pie in the sky, not technically possible for all kinds of content, but still good to try. So the industry as a whole is kind of settling on WCAG 2.0 AA as like its standard. So even if you're looking at this and going, I don't care about the law for some reason, I don't care about disabled users for some reason, you should care that like there's market potential here. Like your customers are going to be meeting this, not customers, sorry, competitors. Your competitors are going to be meeting these standards, and your customers are going to be expecting these standards. So there's market rationale for this too. All right. So I've kind of thrown a lot at you. Let's go for a quick TLDR. Compliance protects real people. People on the other end who might have a variety of needs depending on what product it is you're offering. Web accessibility is the law, probably, put a huge asterisk there, but like we're reasonably certain it's the law. You should protect yourself against this if at all possible. And then when in doubt, adhere to the WCAG 2.0 AA standards. Do we have any quick questions? Yes?
Isn't compliance with WCAG mandatory in the EU?
I believe it is, yes.
Okay, so if you're hoping for an international market, you have to be compliant anyway.
That's my understanding. Yes. Anyone else? Yes?
So, in any of the lawsuits you've seen, are there accommodations, I'm not using that word, for small businesses? Or if somebody sues an independent web developer or app developer, are there cases litigated or just let go because maybe that one individual is not capable of the technical expertise to meet WCAG compliance?
So the question, in case you didn't hear, is have there been any accommodations for small businesses, effectively? Has there been any, I guess, lenience or any different behavior there? Personally, I haven't found any cases that specifically targeted small businesses. Usually the cases that end up being interesting enough to like possibly set a precedent tend to affect companies that you've probably heard of. A lot of banks and insurance companies, for instance, as well as restaurants, and that's especially because those are parts of your daily life. They impact how you interact with the world, and especially as we move to a more internet-based experience of living, like this stuff is even more important to make sure we get right. Ben.
So, I had to fill out a lot of 508 compliance things for bids, federal entities, and a lot of things that were required in there. I think at the time when I was working at a .NET shop, we would simply say, this is handled by the framework. It's automatic, it comes with the framework. So in general, for web accessibility,
Sure.
are you aware of, where the frameworks stand? What can you get out of the box? What needs to be extended? Which frameworks are more accessible by default?
So the answer is, actually, the best answer I've got is, if you want to learn a lot more about specific technologies and how they interact with accessibility, I would go to WebAIM. They recently did a survey of the 1,000,000 most popular homepages, and what they found is actually that the more frameworks sites that use frameworks such as React or Angular were more likely to have accessibility defects. Though they were quick to mention that probably wasn't the fault of the frameworks so much as the framework is being used because this website is more complex. and that complexity led to defects. That said, I have some criticisms of frameworks in some ways that they enable people to follow worst practices. I have a blog post up about adding click handlers to divs to make them behave like buttons, and I think there are ways in which frameworks enable that all too often. But as far as I know, like publicly, the public line from a lot of frameworks is we care about accessibility, and especially from the React community, I have seen an outpouring of support for accessible out-of-the-box solutions and components. Anyone else?
On your browser, are there any tools that you can use for your website to scan it or something?
Sure. So there are automated testing tools. The one that I use most often is called WorldSpace Attest. And what that can do is that can find about half of the possible bugs, right? Because some bugs are going to be things you can calculate pretty easily, like these two colors don't have a sufficient color contrast. That's a thing we can write formulas for. Or this image doesn't have an alt text. So we can write a heuristic for that. But also a lot of accessibility has to come down to, are you creating your page with a clear structure? Are you using components correctly and elements correctly? And the behavioral testing type aspects, the UX stuff. And that's not stuff that you can easily test. So while tools like WorldSpace Attest, Lighthouse, etc., while they can be an important part of making sure you're confident that your page is accessible, it can't be the entire solution. What's up, Ben?
Well, for Noah, I wanted to ask you to talk a little more about the difference between being compliant and truly being accessible. I know there's a really good expert down in Austin who writes and speaks about this a lot. That being compliant says, okay, it can be read by assistive technology. That does not mean that it makes any sense when it's read by assistive technology or helps you navigate. Navigation is typically one of the areas that can be way too complicated to use with assistive technology. I'm just softballing that up to you.
Thank you. I appreciate that. Yeah, absolutely. Accessibility, there is so much room for excellence here. There's so much room to build a positive, enjoyable, delightful experience for different users. And I even know within the accessibility community, there is a general weariness towards having to point to the law and go you should care because compliance. I'm aware of that, but I think also for many businesses, this is kind of the best place to start, right? There's a way many companies will treat accessibility like it's a nice to have or an optional or something we can have for down the road. And sometimes if you want them to care, sometimes you can't just give them a carrot, you have to give them the stick, and that's unfortunate. That is why I prefaced this presentation actually with a talk about how compliance itself is helping real humans. And that's in my mind what it's all about there, is making sure that we're doing the best for our customers and our users because it's the right thing to do. And also understanding stuff like this, because it is a real factor in how we work. Anything else? You can reach out to me if you need me. I'm a huge nerd for this kind of stuff, and I would love to talk to you about it. Thank you so much for having me, by the way.